American Law Institute Continuing Legal Education presents Litigating a False Claims Act Whistleblower Case. Opening the program will be Mark S. Responti of Pietrogallo, Gordon, Alfano, Bosick, and Responti, LLP in Philadelphia. More information can be found in the course materials.
Good afternoon. I'm Mark Responti, and I'm with the Pietrogallo firm in Philadelphia. And if you've tuned into Litigating a False Claims Act Whistleblower Case, you're at the right place. We're going to spend the next 2 hours, and we encourage you to forward questions to us, trying to dissect some of the various components and aspects of litigation of a False Claims Act. And we have a panel that's assembled this afternoon that I think has got about as much experience in the area as you're going to find, I think. And I'm going to turn first to my right and introduce you to Margaret, lovingly known as Peg Hutchinson. And she's Chief of the Civil Division of the United States Attorney's Office for the Eastern District of Pennsylvania. I've had the good fortune to work with Peg for a long time. I don't think there are many people in the United States as experienced as Peg. She supervises all civil, affirmative, and defensive litigation for one of the largest and most active offices in the country, and an office that really has been at the forefront of False Claims Act litigation since the passage of the 1986 amendments. Peg worked on cases before the 1986 amendments, after the 1986 amendments, and continues right until this morning working on some of the largest and most active cases in the United States. She's supervised every type of fraud case and been involved in every type of fraud case as a line assistant, from hospital fraud to pharmaceutical fraud to pricing to quality of care issues to pharmaceutical pricing to defense contracting cases. She serves as a healthcare fraud, she teaches healthcare fraud as an adjunct professor at Drexel University School of Law, and she's a recipient of the Attorney General's Award for her work in fighting fraud, as well as the Director's Award from the Executive Office of the U.S. Attorney's Office. And Peg has a small commentary that she must make before we begin.
Hello, and thank you very much for joining us, and thank you to the ALI for putting together this seminar. As a member of the Department of Justice, we're encouraged to participate and share insights and perhaps guidance with respect to the kinds of litigation we're going to talk about today. But as being authorized to do so, I am also required to tell you that I'm only giving you my personal opinions. I'm not authorized to give you the official position of the Department of Justice, and therefore you will hear Peg opine as opposed to the Department of Justice opine on different topics we're going to cover today. And thanks again for the invite.
So Peg will be covering the litigation of a False Claims Act whistleblower case, obviously from the government standpoint. I've had the good fortune to represent relators over the last 25 years or so. And to my left is my esteemed colleague from Morgan Lewis, Meredith Oughton. And she is a senior litigation partner at Morgan Lewis's Philadelphia office. She is actively involved in qui tam litigation all over the United States. She's also involved in white-collar litigation all over the United States. And she is a frequent lecturer. She writes on the False Claims Act. Many of her articles have appeared in national journals throughout the United States. And she serves with me and several others as a national co-chair of the ABA's Criminal Justice Section White-Collar Committee, White-Collar qui tam Subcommittee, which is the longest subcommittee name I've ever heard of. In fact, I often ask Meredith to go over it with us. But Meredith will be giving the defense perspective based on her experience all over the United States on a daily basis litigating false claims acts. Welcome, Meredith.
Thank you.
So what we've tried to do, or what we're going to try to do, is to take various aspects in some sort of logical order, because litigation has many twists and turns. And we're going to try and discuss them as they tie into the actual litigation of a case. And over the years, there's been a sea change in the way False Claims Act cases had been. I think when Peg and I particularly started working cases with each other and even sometimes against each other many years ago, we would have a case that was filed the government would make a decision whether it wanted to intervene or not. If the government didn't intervene in the case, generally the case went away, and the case would remain usually under seal, and everybody would be generally happy and move forward one way or the other. There wasn't much litigation back then. There wasn't really much areas that would really hit the public eye. Many times a case would remain under seal for many years, and then you'd hear about a settlement the day after the case had been unsealed. In fact, I can remember when I first started doing the work, every week I would read every case in the United States having to do with the False Claims Act. And back 15, 18, 20 years ago, that might be 2, 3 cases in a month. I received my packet every Friday, as many of my associates know, because they have to gather them for me. And now the reading takes an hour and a half, sometimes 2 hours. So there's a lot of active litigation going on. And I think we all are seeing, both from the defense side, from the government side, that these cases are now actually litigating and trying. And so what we wanted to do is to spend a little bit of time today talking about some of those issues that in past years never really got discussed, and try and give you a little bit of our background and our insight that might help you. We're lucky enough to have people who have tuned in today from all over the United States on the plaintiff side, defense side, and the government side. So hopefully, it'll resonate in your districts. Generally, not generally, almost always, a False Claims Act case, a whistleblower case, is filed by Relators Counsel, someone like me, somewhere in the United States in one of the 94 districts. And the False Claims Act, as you know, has a wide latitude when it comes to venue. So where the case ends up is very important, at least it is for Relators Counsel, because frankly, if you go to an office that has not as much experience as, for example, the Eastern District, or does not have the resources or the expertise or the wherewithal to be able to do it, or even the interest, you might end up with a case that really isn't going anywhere and may end up in some of the other litigation buckets. So we typically will contact a prosecutor ahead of time, like Peg or someone in Peg's office. One, frankly, I think is a courtesy, because that's a practice that those of us who do False Claims Act want to make sure that the case has a not only a legal nexus, but a causal nexus, that the agencies and the agents have some connection. I mean, there's a prosecutor once told me that, as long as one claim goes through my district, I can have it there, but that's not always the case, and sometimes that doesn't always make sense. So, but there's also a legal reason to do that, is that the False Claims Act has always had a very explicit pre-filing disclosure requirement that could cause you to lose some rights later on if there is a challenge to public disclosure or original source. So a conversation begins usually before the filing happens. Of course, Meredith or her firm would not be involved in that because you yet don't know about the case.
That's right, yes.
But we're having a discussion with prosecutors to determine, do they have an interest, do they have resources, do they have expertise, do they want the case? And frankly, that's really what goes on.
And if I could just jump in,
Sure.
there are a few things that we talk about when we have that pre-filing conversation or pre-filing meeting, which is sometimes the case, and we encourage that in our office. And some of the things that we talk about is if, for example, the counsel that's now representing this potential relator believes that the conduct is egregious enough and serious enough that it may result in both a criminal and a civil resolution, then we really have to think long and hard about venue. From a civil perspective, it's much easier, quite frankly, to find venue because undoubtedly the conduct could have involved a claim that was submitted or something of the like in our district, or care was rendered, or if it was a healthcare case, or some product was purchased if it wasn't a healthcare case in our district, and we'll find venue. But from a criminal perspective, that's a more challenging analysis. So one of the things that we talk about when we have that pre-filing, where are you going to land this case discussion, is if in fact we think the conduct's serious enough to warrant criminal, then we have to think about the venue issue. The other thing is, and this is an interesting development that we have seen over the years, more and more states now have false claims acts. And so if the conduct is really mostly concentrated in one particular area or one particular state, then we may have that conversation to talk about whether it would be better to file it in a district that has a state that is an active participant in and has its own False Claims Act. Those are just considerations. And the third and most important, which is the one that Mark has mentioned, is the issue of the public disclosure bar. When you are considering representing a relator and you are considering whether to bring a case forward under the False Claims Act, for those of you that are new to this type of litigation, the statute does require that if there have been public disclosures of these allegations of fraud, you can only survive as a relator if you have done two things. If you have brought the information to the government before you filed your qui tam complaint in a pre-filing disclosure. That's the one step that you have to do. And you also have to be able to show that you were an original source of the information and allegations. So you want to be thinking about those two things. So those are the kinds of issues that we talk about with counsel for the relator when we have that pre-filing conversation, and we encourage it. And I agree completely with Mark that to have us be able to give some input or thoughts as to the preliminary assessment of what this conduct is just really helpful.
Yeah, and Peg mentioned, and I'm sure Meredith sees on a daily basis, there are now 29 states that have false claims acts of their own that are modeled very closely to the federal statute. Pennsylvania does not have one, but it is a good thing to try and find if you have a potential defendant or conduct that may involve, say, Medicare or Medicaid if it's a health care case, to find a Attorney General's office that has passed the statute and is active with the statute and has a good working relationship with the United States Attorney's Office for that district, because not all of them have good relationships.
That is correct.
But the ones that do, it can be a very good allocation of resources. And when we kind of start that process, Peg, oftentimes you or people who are working under you will provide someone like me and the relator some rules of engagement. Could you discuss some of those?
I'd be happy to. Whether it be in this pre-filing meeting and conversation or post-filing, we have what I refer to as our rules of engagement letter. And it in essence outlines the process to initiate this False Claims Act case and to encourage both counsel for the relator and the relator, him or herself, to consider, now that they are joining with us to go forward and do an investigation into the allegations, what their role is. We're very concerned, and we make it very clear right from the start, our concern with respect to what kinds of information the relator can gather, what kinds of information the relator may or may not have access to, what information the relator can bring to us, in what form that information can be captured, because we don't want to violate any constitutional rights. We also want to be very mindful of and thoughtful about privileges that may be associated with materials and information that the relator is gathering. So we go over these rules of engagement, as we call it, with the relator and relator's counsel. And by the way, just as an aside, I realize this is a full employment for lawyers statute, but there have been several decisions rendered dismissing qui tam complaints when a relator is not represented by counsel. We don't need to, for today's litigation, litigating a False Claims Act case, get into all of the reasons why, but suffice it to say that the court recognizes the essential role of relators' counsel in bringing these cases forward, and we encourage, obviously, when we get a relator who's called us, who may not be represented and is interested in pursuing something under the False Claims Act, to line up a counsel to work with them so that, for example, this rules of engagement letter that we ask everyone to sign and affirm that they understand has been fully vetted and they understand what their role is and what they're allowed to do.
I used to get calls, not so much anymore, and a potential relator would say, well, call me up, or call my firm up and say, well, why don't I just bring the information to the government, and why do I really need you to get a successful resolution? And my response then, and actually even more now, is, are you capable of landing a 747 on your own? And they say no, well then your chances of coming to a conclusion on your own are about the same. But So we start off the ball, we come and we visit with a prosecutor in an appropriate venue, and we get the ball rolling, Peg, and perhaps you decide on your investigative tools. Maybe you're going to go with a subpoena, maybe you're going to go with a CID, and you might want to comment a little bit on what CIDs are. And I'd also like you to talk a little bit before we get to the next stage of how long the investigative stage currently lasts in a modern False Claims Act case.
I'm going to jump back and
Yeah.
cover a few things, and then I'll answer that question, or dodge it. But to first address the issue of the launching of the investigation, when we get the KETAM complaint, the first thing that we do in our office is we make a copy for our criminal division. We immediately take it to the member of our criminal division who oversees fraud so that they can take a look to determine whether they want to open a criminal file, and in many instances they decide not to open it right away, but may perhaps open one later on, depending on where the investigation takes us. So that's one step.
Is that a practice in your office, or is that working in all offices?
That is a practice in our office.
Okay.
I can't say that it is automatically done everywhere, but I know that the Attorney General has encouraged and has repeatedly emphasized the benefit of parallel proceedings for purposes of investigation. So I think it's fair to say that it's in most offices.
Yeah, I see that in a lot of offices. I just never was sure
Yes,
whether or not it was
yes.
was an official practice.
Well,
So
I think
that's-
in light of the Attorney General's memo from
Right,
last year
right.
on parallel coordination between the criminal and civil divisions, that most offices across the country, there is both a criminal and civil file that is opened
Yep.
when a False Claims Act case comes in.
And the other thing that we do when we get the KETAM complaint is we look to see what is the harm that's alleged and who are the potential federal agencies that have been harmed or have been involved in these particular allegations. For example, if it's a healthcare fraud case, then we're going to reach out to our partners at the Department of Health and Human Services and their Inspector General's office. So when we assess the allegations and we assess the agency that is involved, a copy of the KETAM complaint is shared with that Inspector General so that we can line up potential agent support to investigate the allegations. If, for example, the allegations in the KETAM complaint are that the Department of Defense was the victim of procurement fraud, then we would reach out to the Defense Criminal Investigative Services or the other investigative arms for the Department of Defense. That's to begin the assembling of our investigative team. It may be, depending on the nature of the KETAM, that there may be some states named as co-plaintiffs, an interesting development over the past several years because of the State False Claims Act, where a relator may choose to name, in addition to the United States, but other states who have False Claims Acts as co-plaintiffs, in which case they will have served the states with the complaint when they've served us, and so we will be reaching out to those states to assemble from amongst the states that are named some investigative resources and also part of our assembling our team. We then, one of the first things that we do is talk to the relator. And in that initial conversation with the relator, we're assessing the depth of the knowledge the relator has, we're assessing the depth of the activity that the relator has engaged in, as well as whether, in fact, the relator is part of the potential allegations of fraud. We will assess the relator's background. We will assess whether the relator is a frequent relator, whether the relator has been in criminal trouble before. I mean, some of the questions are less comfortable than others, but all of them must be asked. And the next thing we do is look to what are the different investigative tools that we want to use to address the conduct. Mark asked the question of how long these investigations can take, and they can take years. Should they take that long? No. But in some instances they do, and it's appropriate. In most instances, our goal is to reach that decision of whether we're going to intervene in this case and go forward and join the relator in litigating or not. In that our magic goal is a 9-month period from when the KETAM is landed on our desk. How often do we meet that goal? I don't have statistics on that. But I know that it is a goal. And one of the things that has recently been extremely helpful to us in this reaching of that goal and in the emphasis on expediting our investigation is the use of civil investigative demands, or as Mark referred to them, CIDs. The statute was amended to allow for the issuance of CIDs. It had always been, sorry, I'm misstated, it had always been authorized in the statute to have a CID issued. But until recently, the only person who could actually issue a civil investigative demand was the Attorney General himself or herself. And a civil investigative demand was perceived as a very powerful but also intrusive investigative tool, because a civil investigative demand can ask for answers to interrogatories, can ask for documents to be produced, and can ask for a deposition to be taken of a person under oath. All of this before we have filed a complaint. So because it's such a powerful tool, the only person who could authorize the issuance of them was the Attorney General. Pursuant to an amendment in the statute, that has now been changed. The Attorney General has now designated and delegated that authority, and it now can be issued by the U.S. Attorney in the district where the case and the investigation is pending. Our U.S. Attorney has been a wonderful partner with us in the Civil Division in the issuing of civil investigative demands, and that has helped greatly in the expedition of the investigation and helping us to be much more efficient.
A few years ago, before the statute was changed, because it took so much time and effort, although I did have the benefit of a number of CIDs from the Attorney Generals over the years, that those of us in the plaintiff's bar, when we named a state, and Peg raises a good point that sometimes many times we're naming states, particularly in healthcare type cases, some of the states had a much easier time of getting a CID.
Mm-hmm.
And so they could have a CID out in a few days, where the United States Attorney's Office or the Justice Department could take months or years.
Mm-hmm.
The CID is one of the areas where someone like Meredith would first know that there is an investigation. You know, typically there might be a subpoena, and obviously she doesn't always know that, but generally, why don't you talk a little bit, because we're talking now in the stage we're discussing. The case has been filed by me. Mm-hmm. It's being investigated by Peg and her team and maybe the states. And maybe out of the blue, you receive a copy of a CID or someone in your company, and talk a little bit about what your thinking is at that point in time. What are you processing at that moment?
Okay. Well, let me first sort of give the defense perspective, as Peg and Mark have been talking about the beginning of the whole process of filing of the key TAM complaint and making the disclosure to the government. From the defense perspective, of course, we do not know for sometimes many months, maybe many years, that there is a key TAM complaint out there. And there are a lot of conversations and discussions and gathering of documents, analyses, and theories that are sort of worked through between the government and the relator over the course of the investigation that obviously the defendants don't have a chance to come in and address or deal with in an early time period. So from the defense perspective, that's always a difficult aspect of these cases, is that they are under seal and we're not aware of them often for a very long period of time, and then when we come on board, we need to play catch up. So an interesting thing over the last couple years, ever since the change to the False Claims Act, allowing the issuance and the delegation of authority of CIDs, is we are seeing a huge increase in the number of CIDs that our clients are receiving. And they are receiving them, it seems, relatively early on in the investigation process. So there are some benefits to that, and there are some downsides. So the benefits are, once we see a CID, we can almost immediately assume there is probably a key TAM out there somewhere. And we can begin on the defense side our investigation and determine, based on the particular requests that we see in the CID, we can determine what line of business, what folks could be involved in it, what could be the core issues, and we can start our investigative process. So that's always a helpful aspect. And then we can also start our dialogue with the government and start to build our case and our defense and convince them that they should not intervene in the case and that the case should go away. The downside to CIDs, and Peg has alluded to this, is it is a very powerful tool. A usual grand jury subpoena is for documents. A CID authorizes interrogatories, document requests, and depositions. and in a very early stages of an investigation, while on the defense side we're still trying to wrap our arms around it, to ask us to respond in written responses, interrogatory responses, is a very difficult proposition. It's even more difficult to ask us to bring somebody in for a deposition when, as we've alluded to, there's an open criminal file. So you have potential issues with whether a witness feels the need to assert the Fifth Amendment, which then makes our position very difficult in the litigation and in the investigation to convince the government to step away and to be able to get our side of the story out there. So it presents, the CIDs present a number of challenges that I think we're all working our way through because they've become more prevalent, and I think we're going to see some more court involvement early on in these processes, because some of the CIDs that our clients have been seeing have 30 to 50 interrogatories, document requests, numerous requests for depositions, and that's a very onerous burden very early on in the process when we've got to protect our clients' rights and interests. So there are upsides and downsides.
Right, and so far we've been really talking more about process and the beginnings of what I would call advocacy. We haven't really gotten to the litigation part, but we need to really make sure the audience understands as it's processing. Now, Meredith touched upon something in which sometimes the first time there is any actual litigation is if a potentially overbroad CID or overbroad request, although it's been my experience that the government is pretty careful about that, but should the defense counsel or defendant or potential witness be hit with that, you have to be very careful when you go into the court. And sometimes it's an opportunity for defense counsel to figure out who the court is because they really don't know. Generally, at this stage in the proceedings, although I've filed a case with the court, there's not been that much court involvement generally, although Peg and I have had some courts who are taking an activist role right from the moment of the filing, and I've had a number of those over the years where every 30, 60, 90 days judges like to have an update on what's going on. But generally, it's relator, government agents, less involvement with the defendant and defense counsel, unless there's a need to move quicker for document or search warrants or this and that. The investigation takes its course. I think there are attempts to put time limits in. I think those time limits are not always honored for a whole variety of reasons, and sometimes judges will be a little bit restrictive. Sometimes they can be persuaded. Sometimes you're working with the government to try and persuade the court that we are working as quickly as we can and there are legitimate reasons that it's taking some time. And sometimes it really be helpful to have the court involved because it's taking too much time because it shouldn't. So that process is going on. And I think in the older days, if you will, that process led to usually a simple decision. Government's going to intervene, the government's not going to intervene. I think that's completely changed. And I'd like you, if you could, to start off that conversation as to how it's changed, and I might add a few of my own thoughts.
Let me just jump back because we do
and
have...
we will be doing that back and forth because there is no straight line on litigation.
We do have folks joining us today from all over the country, and it's interesting to appreciate that the way cases are assigned to the judges in your respective district is different. And there are some districts where all of the key TAMs that are filed under seal all go to the same one judge. In other districts, such as mine in the Eastern District of Pennsylvania, it comes to the next judge on the wheel. And there are some judges that will allow us as much time as we deem appropriate and necessary in order to do our investigation without hurrying us along during that pre-seal lifting day. There are others that, as Mark said, will be every 30 days expecting an update as to why we haven't been able to make our decision whether to intervene or not. And during that process, if in fact we have requested, for example, documents from one of Meredith's clients, we have on some occasions actually asked the court for permission to disclose the existence of the key TAM to the defendant, so that the defendant can know that it's there before we have made that decision to intervene. And we have actually, in some instances, had the defendant join us in requesting of the court that there be given more time to keep it under seal because the defendant wants to make a presentation to us about a particular issue or wants to have us consider certain information and facts before we make that decision whether to intervene or not. And so it is a very fluid process. It does change day by day. It does change judge by judge, and frankly, it does change district by district. And you need to know that when you go into it as to how it will work in your particular district. But at some time, we're going to get to that point. We're going to be asked to make that decision. Are we joining in the case? Are we intervening or not? And as Mark said, it has taken on a lot of different forms. In the past, it was, yay, we're with you, or no, we're not with you. It was either we're intervening or we're declining to intervene. Seal gets lifted and we're off to the races. Now we have seen a much more interesting development. We have seen where the government has made a decision that they're going to intervene only as to part of a complaint, for example. They'll intervene on counts 1 and 3, but not on 4 or 5, for example. Or we're intervening only as to certain conduct, or we're intervening only as to certain years of the conduct that's alleged in the complaint, or we're intervening as to certain states. So we could have what is called or referred to as a partial intervention, at which time the government would file their complaint and intervention, crafting and alleging the facts that they're intervening and wanting to go forward. That's one option. Another option, which we've seen often, is we will decline to intervene, but we remain active in the litigation for a lot of different processes that go on that I'm sure we're going to get to, such as the government filing what has been referred to as statements of interest. We have seen the government on occasion not being prepared to make either an intervention or declination decision, and it's sort of a we don't know. And we have done that on occasion, and because all of these decisions require a great deal of vetting and authority throughout the Department of Justice. So Mark is right in that our decision is not as clean as it has been in the past, and frankly, it leads to some messier litigation than it has in the past.
Yeah, I mean, the government can, and this is really the first time I think that the parties then are starting to interact and have contact with the court and begin the process of litigation. I mean, and I think all the things that Peg described are happening much more frequently than ever, including we just don't know whether we want to make a decision at this time or we'd like to see what you can do or get past a motion to dismiss. Resources have a lot to do with it too. There's been a cutback in resources. Anybody that has lived through the last 60 days with multiple government shutdowns knows that there's been sequester and other issues, hiring freezes. I think, frankly, on the good side, many in the Department of Justice have decided that, well, maybe the partnership that was forged with the passage of the amendments really have to become more of a partnership, and we have to stop acting like we're in control, because sometimes we're not, and sometimes it's the lack of resources that leads to more partnering with the private bar. There also is an interesting advocacy that is beginning, and actually pre-litigation, in that government deciding where they want to be, defense counsel trying to figure out if the relator is going to go forward, and if so, on what. And maybe the Department of Justice in Washington or in the local office, federal government is not going to go forward, but maybe states are going to go forward, which causes some issues for you too, Meredith. So why don't you discuss some of that dynamic as it's working?
Yes. Well, as Mark alluded to at the beginning, I mean, there really has been a sea change in False Claims Act and qui tam litigation over the last couple of years that we're really seeing in practice. And one of the interesting things that we are seeing is this increase in decisions to, non-intervention at this particular time. And what does that mean for all of us in practice? It puts sort of everybody in a difficult position, because on the defense side, we're working hard to get the government to decline to intervene. We want them out of the case entirely. And by out of the case, we also do not want to see all these statements of interest, which we are seeing over and over and over again in these cases. And I think that a lot of these statements of interest, when the government hasn't made a decision to intervene, sometimes sways some of the judges when they're looking at, the government is not in, but they have a very important interest here, and they're the real party in interest, and they're going to take a very hard look at that statement of interest. And so we want to keep, on the defense side, we want to keep the government, every government, the federal government, the state governments, on the sidelines and out of the litigation. No statements of interest. We want them to decline to intervene. But the trouble we face with this non-intervention at this time is that we find ourselves in the middle of litigation. At the same time, we're continuing to try to present to the government to keep them on the sidelines and have them make that final determination. So it's been a different practice than in the past, where there was sort of a very clean decision. Now, in many cases, it might take a couple years for that decision to be made, but it was going to be either they were in or they were out, in the past. And now we're facing this issue of this limbo of, at this time, they're not sure if they're going to be involved or not. So this has sort of posed some challenges, I think, for us on the defense side, for sure.
If I could just jump in on that. The interesting dilemma that Meredith and her clients have of wanting to address a complaint with a motion to dismiss is what triggers the statement of interest. And I have shared many times with my colleagues as defense counsel that the broader they go with their motion to dismiss, the more likely they're going to have a statement of interest from us. And what are we talking about? The complaint has now been out from under seal. The government has done whatever it's done in terms of, yes, I'm in, no, I'm not, or I'm thinking about it. The complaint gets served on the defendant. We're off to the races. The defendant and defendant's counsel now are presented with this complaint of the relators, and they want to file, or are considering whether an appropriate next step in their litigation is to file this motion to dismiss. When I tell them, look, the broader you make it, the more likely you're going to bring us back into the table. And the reason for that is if the motion to dismiss is, under no circumstances could this ever be fraud because bop, 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 it invites from the Department of Justice you've gone too far. There's the possibility of a potential False Claims Act liability under the following circumstances. And it's that kind of statement of interest that I'm talking about. So I encourage you, if you're in Meredith's shoes and you're representing a defendant and you're thinking about whether to file that motion to dismiss, if you truly want to keep us in the sidelines, don't do it as such a broad document, because you'll be inviting our response.
Yeah, and let me kind of address a couple of other areas in this important dynamic period of trying to figure out what the contours of a complaint will be and who the parties will be. And this is how I describe it sometimes to my associates, and you might not accept this, but I think you would unofficially. So a relator goes forward on his or her own, and they're representing basically the United States in that the financial reward, the majority of it, will go to the United States, but they're really acting on their own. Peg is the chief of the civil division, and her counterparts are really the guardians of the jurisprudence of their district. And so they're the first line. Every time a complaint comes out, and they should be, and I know that they are, monitoring what's happening, because just because they're not part of it doesn't mean that that case isn't going to affect the next 10 cases coming down.
Right.
As that case works its way up through the circuit courts, Peg's bosses, if you will, in Washington, become the guardians of the jurisprudence nationwide or in the circuit. And they work their way up to the point where you want to make sure, if you're the Department of Justice, you're watching what gets to the Supreme Court or not. But it begins oftentimes with a case in a district somewhere with someone on the government side either kind of watching what's going on or not. And sometimes these cases can meander off into certain areas. Now, I agree with you that the statements of interest can be very, very helpful from the Department of Justice, whether a case is going forward with the department or not. But, and they can sometimes beat back defense counsel when they're trying to claim that this is not where the law is. And it does send a signal to the courts that there's some interest in it. But the statute does two other things for the government. The government can move to dismiss a complaint that it does not believe is appropriate. Now, they don't do that often. And I think the reason that the government doesn't do it that often is that, well, I think there's a political reason. I think you wouldn't want to be in the position of constantly trying to dismiss relators' cases. But the more important thing is I think that the statute allows these cases to go forward. There have been a handful or so, I think, over the years that you've moved to dismiss.
Oh, I'd love to jump in on that.
Go ahead.
That, I think, is one of the areas, as we crystal ball predict how litigation is going to develop in this arena. I think the motion that Mark is referring to is under 3730C2A, which allows the government to move to dismiss a complaint that the government doesn't feel should go forward. And we have been asked many times by Meredith and her
Yes,
colleagues,
yes,
why
and
didn't you
we
move
would
to
love
dismiss?
you to do it more.
And we hear
would,
you.
yes.
We hear you, because our concern is, amongst other things, that we want to protect the law, that we want to make sure that the law is appropriately applied and used to address what it truly was designed to address, which is fraud on the federal fisc. And we don't want it to be used for things for which it wasn't designed. So the encouragement for us to go forward and to move to dismiss has been certainly increased, and the number of times that we have done so has certainly been increased. You know, I hate to hide behind the resource banner, but I shall. We have limited resources, and if in fact we are going to commit the resources that we have, the precious resources that we have, to investigating and ferreting out fraud cases, we don't want them to be spending time moving to litigate, moving to dismiss a case for which has no, in our opinion, no merit. But we have done so, and we will continue to do so. What's interesting about these C2A motions, I'll just be super quick, is there's a split in the circuits as to what is the standard that the government must meet in order to file a motion to dismiss. In some districts and circuits, the court has recognized the unfettered discretion of the government in making a decision of whether they should go forward with a case of this type, and they have essentially said, you have that unfettered discretion, we're going to accept your position when you move to dismiss. In others, we have to have a standard of meeting an arbitrary and capricious. In other words, what is our goal in moving to dismiss, and have we met, as a dismissal of the case, met that goal, or is it arbitrary and capricious? The interesting thing about that is, in either event, the relator, according to the statute, is entitled to a hearing. And the real question that the court then is presented with is, what constitutes a hearing? What is it that the government must present at that hearing in order to meet the burden, whether it be the unfettered discretion burden or this arbitrary and capricious burden? What is it that the government must present to the court at that hearing in order to meet that burden? So these are all considerations that we have taken into and reviewed when we're making a decision of whether to file a C2A motion. But I do think that they have been on the increase, and I think you're going to see more of them.
So whether the government has intervened or not intervened, it does pose, the government still needs to be involved in either reading the pleadings as they're being done, taking an active role, because I think there are times where, I think, Peg, you would agree that even when you didn't intervene in a case, that a lot of good case law has come from cases that the government did not initially intervene in. In fact, whole broad areas of the law, including off-label marketing, came as a result of no government involvement. But it's very important from the relator's point of view, and probably, well, not probably, certainly from your point of view, to keep up the communication, because I want to make sure that I'm keeping the government advised, even if they don't want to be advised. Sometimes they don't. I just keep them advised, here's what's going on, do you want to do something about it? And then no one can say that they can't, but if I get to a point of a settlement of a non-intervened case, the government has to be involved. If I get to a point where I want to dismiss a claim, the government has to be involved. If I get to a point where I'm settling other claims other than False Claims Act cases, state causes of action or discrimination claims, perhaps with defense counsel, I have to make sure the government can take a look at that and make sure they're happy with it. So there is that level of communication that's going on, that should go on, that statutorily is required to go on. Because in rare occasions, although not, I think, of increasing amounts, the government can come back into the case at a later time. And I think that they're being more forthright about saying, we do want to monitor the case, and we might come back after we've done this or that.
We put that in our proposed orders. When we if we file a notice that we're declining to intervene, we have in our proposed order that the parties have to give us copies of depositions, give us notice of discovery steps, because we are constantly reviewing it to make a determination of whether it's appropriate at some point later in the day that we want to intervene, and we can do so for good cause. That is how the statute is worded, and so if there's new information that is presented to us, or a new theory, or in fact new facts, we will certainly take a look at that, and we encourage both parties to keep us informed as we go forward.
All right, so the case is going forward now. It's either whether it's intervene, partially intervene, a state's involved, just a relator. We've served the complaint on the defendant, or maybe we've more likely called the defendant and worked out the service process. And now you have a complaint, Meredith, and you've been studying it, and maybe you've seen it for a year because
Yes.
Peg was kind enough to share it with you as a result of a partial unsealing order. And why don't you tell the audience what it is you want to do to my complaint after it's been
Oh, I
served on
can't
you?
wait. How long do I have to talk? Okay. Let me back up for one moment to talk about the partial unsealing of the complaint that Peg's talked about with the defendant. This is a relatively common practice, and there are a lot of helpful aspects to it. First of all, from the defense perspective, we love to see exactly what the theory is. If we have not figured out the relator, obviously, that we are usually able to take a look at that, right in the complaint. We can see the theories, we can see all the allegations, we can start to wrap our arms around it. And there are some circumstances where we might take a look at it and determine maybe this is one that can be resolved now, before actual litigation commences, before discovery goes forward. Maybe we can get both the government and Relators Council on board. We can find a resolution to this, a quick and easy one, and then it all gets resolved while it's under seal. Then it comes out for the settlement purposes from under the seal, and it's done, and you've put it behind you. So we've had some good experiences with looking, at a complaint and having it, partially unsealed and taking a look at it and being able to come to some type of resolution. Sometimes that resolution might be, we might be able to convince in a proffer to Relators Council that this is not a case to go forward on, and we might have this type of magic silver bullet that we can convince folks this is not one to go forward on, or we can determine we have a potential exposure here and maybe we can wrap it up now. So there are some positive aspects.
So your
and
advocacy
benefits.
with me has failed. And you have a complaint that's
Yes.
public. What are you going to
Yes.
do to the complaint, if
Okay.
anything?
So
Because I want you to
what we
answer
usually-
my complaint. Right?
we'll get to that.
All right.
So what we usually do is we obviously first look at it to determine, is there a basis for a motion to dismiss? In almost all of the circumstances that we have on the defense side, we come up with at least one theory that could work on a motion to dismiss. So the very first thing we usually do is a motion to dismiss. Now, those have evolved over time in different ways and with different theories. The motions to dismiss very much depend, as we've talked about here, on the jurisdiction that you're in. And one of the most common on the defense side motions to dismiss that we file for these qui tam complaints is a motion to dismiss under Rule 9b for failure to plead fraud with particularity. Now, that has had a lot of success in certain jurisdictions where they require a relator to come into court with a false claim in hand and the specific identifiers of that false claim, the who, what, when, and where, the amount that was billed, who it was billed to, and so forth. In the EDPA, that does not work very well. The case law here is not good for those 9b motions to dismiss on the defense side. But if you're in the 11th Circuit and in the 10th Circuit and some other circuits, it's a fantastic and winning argument. The problem also with Rule 9b motions to dismiss is that they are often without prejudice. They are going to give the relator a chance to come back and try their pleading again. Now, sometimes the second or third time you can get it dismissed with prejudice at that level, but sometimes the relator is able to come back with more facts to get past 9b. So those have been a little harder to win recently because a lot of the courts are looking and trying to give the benefit of the doubt on the relator side that they are going to be able to come forward with more facts over time. So one of the other very popular ones, and ones where there's been a lot of success, but there has been a change in the statute that I think might make it more difficult going forward for us, is the public disclosure bar that we've talked about. There are many cases, and some of these pricing cases, the AWP cases are an example. There are tons of them all across the country. Many of them have been there for years. They have been resolved. We are coming, and seeing out from under seal additional ones now, and that is a clear, terrific argument that information about pricing and issues has been disclosed for years, and these types of lawsuits are the parasitic and opportunistic lawsuits that the statute was not meant to address, and the public disclosure and failure to be an original source argument has had a lot of success on the motion to dismiss level. So those are two that we've used a lot and that have a lot of success. And then general sort of failure to state a claim. If it's an anti-kickback claim and there's not even anything that ties the conduct to any kickback, or there might be a surefire safe harbor that you don't need to develop facts with respect to, that could be a surefire winner. That's been an area we've used. We are also seeing more of successor liability cases. We just had one that we got dismissed out in Utah because you do find a lot of organizations that take over or acquire the assets of another organization, and they find themselves being looped into the hook on a key TAM complaint, and the courts are now starting to look at those issues and the fairness of holding a successor corporation that had no involvement in the underlying conduct and holding them on the hook just because they made an acquisition. So that we're seeing a little more of, and we just had success with that on one of our motions to dismiss. So the usual first place we go is a motion to dismiss. I think some of those are harder to win recently than they have been in the past. There are occasions, and we just had one where we actually answered. We answered the complaint, and we asserted a number of affirmative defenses, and Mark can talk about affirmative defenses and what the Relators Bar has been doing to the defendants with respect to affirmative defenses. And then we have moved for judgment on the pleadings, which is a new and different way to try to approach it if you don't have a surefire motion to dismiss winner.
Yeah, and the motion to dismiss stage is very important because the defendant is trying to obviously nip out claims, and wherever they can find a parasite, which they love to call us, they can find it. I think if we're litigating with the government, which we've done many times, the government's trying to make sure that an area that they want to protect for this case and other cases, and this motion to dismiss stage can sometimes go on for years. There are times where a motion to dismiss is filed against a complaint. I might decide to amend the complaint
Yes.
to correct it, and then of course the
we
defendant
refile.
comes in again,
Yes.
and I've had 3 or 4 of those. Another interesting area, 2 kind of side notes to that. In modern key TAM litigation, you often have 2 or 3 years, sometimes you have a year that you're going back and forth with a defendant where you have had access to all this CID material or material that they voluntarily, so then the defendant gets up in court and says they don't know what the case is about. That's getting more and more difficult, and you're going to start to see more motions, I think, being brought. Or if the government decides to be on the sidelines for the moment but has access to the documents, and if 70% of the money is going back to the government, why should the government kind of sit on that information? And so you're starting to see subpoenas and motions for the government, particularly in EDPA, where it happened, to get informations. And I think courts are starting to think that maybe that's not such a bad idea if, at the end of the day, it's all designed to figure out whether or not there's actually a case here. In the past, I think if the government declined on a case, it tended to be a taint on the case for the relator. I have not found that in recent, I mean, I do think courts, and I practice all over the United States, I think courts are really starting to give the relator the benefit of the doubt on a motion to dismiss stage for a whole variety of reasons. I think sometimes courts think that this is the way it should work. Sometimes courts are a little bit concerned that maybe the government should be doing more, that they're not. A lot of other reasons in between. But I do start to see that there has been, and I think most of my colleagues have seen there's a change. But
Well, there's one invitation for us to file a statement of interest. If the defendant's motion to dismiss says, and they used to do this often, well, the government didn't intervene, so they didn't think much of this case.
right.
And that's an invitation for us to say, whoa, that failure to intervene should never be deemed a final assessment of the merits of the case, because there are so many different reasons why we will not intervene in a given case at any given time. So you want to avoid that if you're a Meredith scamp, because you will then invite that statement of interest from us.
Yes, and we don't want to do anything to invite the government to come on board. So we do not make that argument, and I'll tell you, there's no judge who is interested in hearing that argument. They know there are a number of reasons why there's a non-intervention decision or declination of intervention, so that argument goes nowhere.
But Mark raised another interesting point, and that is the what are the different roles. Now that let's assume for the sake of where we're headed for the moment that the government did not intervene. So we're not an active member of the litigation at this point in time. And let's assume that Meredith's motion to dismiss, while brilliant, didn't survive, and she has to answer Mark's complaint, and we're off to the races. What is the discovery issues that are presented to the various players? And I think that you touched on it, and I just wanted to follow up on it. What is the government's role at this point in terms of discovery? Because, as Mark said, so much of the information perhaps developed during the pre-filing or during the decision to intervene investigative stage is now in the possession of the government. And can the government just give this information to the relator and or the defendant for purposes of litigating? It's a very challenging point in the process for all three of us. And the reason that it is so challenging is before the intervention decision and before the complaint comes out from under seal, and back when we're in that CID stage, the statute allows the government, but doesn't mandate the government, to share the fruits of those CIDs with the relator for purposes of having the relator assist the government in that decision of whether to intervene or not. Once the decision is made, once the seal is lifted, once the complaint has been served, the use of civil investigative demands is no longer available. The civil discovery process is what is now in place. Civil investigative demands are no longer the tool that can be used. And then the question becomes, can the government continue to share that information that the government possesses? We take the affirmative position, and it has been, in fact, affirmed in many different cases, that once that decision is made, if we have not intervened, we're not an active litigant. And therefore, to get information from us, you have to follow the traditional subpoena the government route, which is referred to by many as the TUI process, because of a Supreme Court case that controls us producing information in our possession and control pursuant to a Supreme Court decision named TUI. And that's a very challenging additional step for both the relator and the defendant going forward with these cases.
Right. And we'll get, I want to go do a sideline and come back to that,
Okay.
because it's a very good point. So one thing I think we should touch upon is that the motions have failed. You're answering the complaint, and now you have 70,000 affirmative
Yes.
defenses. I think in the old days, we'd have those 70,000 defenses. You would use them wherever you could. Many of us in the plaintiffs' bar are now challenging you, and the government are challenging you on some of those and are succeeding.
Yes.
So why don't you talk a little bit about striking of affirmative defenses?
Yes. So our usual practice, if a motion to dismiss is denied, and obviously we have to answer the complaint, is to then throw in what I would call the boilerplate affirmative defenses that go on for about 40, 45, 50 affirmative defenses. We throw everything in there that could possibly come up during the course of the litigation, during the course of discovery, that we could use on summary judgment, we could use at trial, whatever it may be. You have latches, you have everything you could come up with, we put in the affirmative defenses. That was the historical practice. We have been getting pushback not just from Relators Counsel who have filed motions to strike affirmative defenses, but also from courts who have said, now this affirmative defense, you're just making it up. There's often a final boilerplate affirmative defense and whatever other defense we may come up with over the course of the litigation. And the courts have said you cannot put in that affirmative defense because it's not even a defense, it's a general catch-all. So we've taken now a different approach with respect to answering the complaint and asserting affirmative defenses, and we've actually started to put a lot more details in the affirmative defenses. One significant area in the healthcare arena are the cases that are brought in connection with the anti-kickback statute. And there are a number of affirmative safe harbor defenses. And with respect to those, we have been outlining in detail the affirmative defense under that safe harbor, exactly what the facts and scenarios and the law is with respect to those safe harbors, and because we want to make sure that there is no motion to strike that affirmative defense, because it is a critical defense to the anti-kickback and also to a number of the Stark allegations that are brought in these key TAM complaints. But we've now been much more measured with respect to the affirmative defenses that we are including, and we're providing some more details because we don't want to find an important affirmative defense being struck because we did not provide the details behind it, or there's no support for it, or it's some general catch-all. So that has certainly been an area where we've been much more aware, and where Relators Council has been filing a lot of motions, and the courts have been granting those motions and giving us provisos that, you know, those types of affirmative defenses are not to be included.
And from a litigation point of view, whether it's the government with the relator or the relator on their own, I think you need to frame the argument in terms of judicial resources. If there's 50 affirmative defenses, we'll spend 5 years just tracking them down. And I think courts have decided that some of them are not appropriate, and I think that they weren't things that were raised enough, but I think are starting to be raised by litigants a lot. So I think that the defendants are becoming a little bit more sanguine about some of those. Now, the areas that they've become a little bit more aggressive about, which I still am not sure is a great idea, are filing of counterclaims.
Yes.
Which I would call slap suits. But why don't you talk a little about the counterclaims?
Okay, so yes.
Even against the government at times, I think. Yeah.
Absolutely.
Counterclaims, yes. So again, in this sort of theme that we've been talking about with respect to the sea change in this type of litigation, counterclaims, and I'll talk, first about counterclaims against relators, have become more common. Historically, we never would have filed a counterclaim against the relator for a number of reasons. In the first instance, the courts take a very dim view, and the law is very strong against counterclaims against relators, because it sort of flies in the face of the purpose of the statute, which is to encourage whistleblowers to come forward. If they're going to find themselves then subject to retaliatory actions, that was a problem for a lot of courts. They took a very dim view of counterclaims. In addition, the atmospherics of filing a counterclaim. If you don't already have a retaliation claim in the key TAM complaint, you're probably going to walk yourself right into one. And those retaliation claims can have very significant impacts on the litigation and how the case proceeds and how the court looks at the conduct of the defendant. And it could have the judge look at the defendant in a different light with respect to a counterclaim that comes out. They have, however, become more common, and we have recently filed some because what we have found are independent causes of action against the relator that we believe are going to withstand scrutiny. And actually, we've had a couple of recent court decisions that have denied motions to dismiss counterclaims against relators. And some of the theories that we have been pursuing are breach of, your duty of loyalty, breach of your fiduciary duties in the case of, say, an auditor or somebody within the company structure whose job it is to investigate and find issues and report them. If they're not reporting them internally to the company, but then taking their findings and filing a complaint, that was not what the statute was meant to address. So we've had some counterclaims on those bases. In addition, a very critical area where the courts are giving us a lot of traction on the defense side is there are relators who are walking out with privileged and confidential documents and materials, and courts have been concluding you cannot make a key TAM case out of privileged documents to which you are not entitled and to which you do not own the privilege with respect to. And actually, there's just a recent decision that came out that knocked out a former general counsel from being a relator and knocked out his complaint because he went far beyond what he needed to bring the complaint and disclosed client confidences and privileged information. And we take a very hard stance on the defense side with respect to walking out the door with privileged and confidential documents and using them to build a case. So we are seeing more in the counterclaim arena. There's a little more court support for letting those claims go forward, although they're still relatively rare, and we do rarely do them for the other reasons I mentioned.
Could I just jump in on the privilege issue, because that's a really good point. And that comes up at every step of this litigation. Yes. It comes up when you're putting together your pre-filing disclosure. It comes up when you present your first matter if you're the Relators Counsel to the government. It has come up, and there have been some interesting decisions where the government has set something aside that they received from a relator and Relators Counsel and said, we're not going to consider this. It appears to be attorney-client privileged, and it's not the relator's privilege to waive, as Meredith has said. And so the reason I mention it is because you must remember that there's a judge assigned to this matter from the minute it's filed. And in some of these cases where the relator or the Relators Counsel relies on a privileged information and has used it in their complaint, once the complaint comes out from under seal, one of the first things the judge has said in 2 of the cases was, why didn't you come to me sooner? Why didn't you, Relators Counsel, come and seek guidance from the court? You knew who I was, you knew I was assigned, you knew it before the case came out from under seal, and you started to litigate it with the defendant. I could have given you a position one way or the other on whether this was in fact privileged or not, so that it didn't result in the being included in the complaint, served on the defendant, and then the subject of a counterclaim. So I think that's just an interesting piece to consider as you litigate.
Yeah,
this.
I think an entire session could be on just that issue, but I think we should be mindful. It is an area that often comes up. We should be careful about it from the plaintiff's side. Defense counsel are always looking for privileged boogeymen, as they should at times. And it's sometimes a thorny issue as to when you go to the courts. Not all courts like to be bothered by it.
You're right.
And sometimes you can take upon you a taint that you didn't want, or taint an entire government team, and you're not really looking to try and drive government prosecutors away from your case. You want to have them come embrace your case.
That's true.
But let's go back to the point that Peg made about discovery on the government as opposed to with the government, because what's happened is too often that the government holds many of the answers that the relator needs. Sometimes the ones the government, the defendant needs too. And I find that there tends to sometimes be what I call the two-way dragging of the feet, because it's a pain to try and engage the agency who's not really part of it. The agency is downstream from the Department of Justice. You know, you're having to deal with that agency on a million things on a daily basis. So it becomes, a TUI request can sometimes become a lifelong process to try and get documents out of the government. Having said that, if you follow all of the rules and regulations, which are cumbersome, the TUI regulations, courts don't like the government dragging their feet either. So if the relator has done what he or she has to do, and personally what I always try to do is informally go to the government first, try and work it out with the government, try and narrow the requests, and try to keep the litigation as the last step when I finally got to a point where I'm not getting it the normal way. Because there are deadlines on the litigation, and then the court's going to say to me, well, why did you wait? You should have gone to the government, you should have come to me. Hold letters, you know, when you're proceeding and you perhaps proceeding against a couple of entities on the defendant's side. You know, do you issue a hold letter to a government agency? Do you send a subpoena? Will the government agency even honor my hold letter if I send it to it? So from your point of view, from the government's point of view, talk a little bit about that, because I think that can cause more and more tension there.
These are all really, really challenging issues and good issues for us to address for all of you. Let's assume, for the sake of discussion, we haven't intervened. We're taking the position that we're not an active litigant, and you need information from us. I think the best approach is exactly as Mark described, which is, first of all, narrowly focus on what it is you really need. Do you truly need, for example, all of the claims data for all of the years impossible, or could you start with a specific piece of time or type of claim in the healthcare arena, for example. In a Department of Defense procurement fraud matter, do you truly need all of the interaction that went on in the letting of this contract and the life of the contract once let? Or can we focus on specific time periods or specific players or people who may be able to provide the strategic information? The more focused your request, the more likely to get success and get a response from the government. The broader the request, the more likely that the government will pick up their TUI manual, which has in the first several pages, all the ways we can say, no, we're not going to give it to you, and engage that way, because after all, we're not active litigants at this point, and it's another drain on resources to be pulled back in to provide information, especially when, if you're in a district such as the ones Meredith mentioned, where the expectation from the court from the very beginning is that the relator can meet that 9B challenge and identify specific claims that are false without any assistance from the government, because after all, they brought the complaint. So it's a really challenging point in the litigation, and I encourage that strategic and surgical searching for what you really need and engaging with the government as to the best way to procure it. What is very interesting to me and has been used by some people is they've also pursued the information by way of FOIA requests, because some of the information that is out there and available pursuant to FOIA. Now, do we like that? To be honest with you, no, because I like to know exactly what's going on with respect to what everyone is requesting in this litigation that I've already been involved in. But the agency from which the information is sought has a whole separate team that handles FOIA requests, and it may be in some instances, and we have had in some instances, where the defendant and or the relator have obtained information by way of FOIA, in addition to the more traditional way of asking us through our TUI regs. So those are two different things that I wanted to address. And the last question Mark asked of me is the question of when does and if the government would issue a litigation hold. Will we preserve information that may be tied to or related to ongoing litigation? The government has, on many occasions, issued litigation hold in affirmative fraud cases when the government is pursuing that authority to intervene, when the government has certainly intervened. But we take the position, and it has been blessed by district and circuit court decisions, that if, in fact, we have decided that we're not intervening and we're not an active litigant, that we don't have that same affirmative obligation. So this is a really dynamic and ever-changing obligation on the part of the government.
Yeah, the interesting nuances is that when the government's not actively litigating, there are different court opinions as to whether the government is still even a party.
Mm-hmm. Mm-hmm.
And so there are times where I've actually considered third-party discovery. You know, I wrote down FOIA for the FOIA request too. And I think you'll see people do that when they become frustrated with the TUI process.
Yes.
So, you know, there are times where you just have to become redundant because the court is not going to give you the amount of time you need, and you're going to run the clock. And sometimes, you know, maybe that's in your interest and your interest, but it's not in the interest of moving the case forward. There are other kinds of typical skirmishes that occur, whether the government's involved, it's relators counsel or defense counsel. There seems to always be, and I think most of them can be worked out if you know what you're doing, but there's always a confidentiality issue, right?
Yes.
I mean, oftentimes there's a HIPAA issue, a proprietary, and I routinely work with the government to work with defense counsel. If defense counsel are not trying to cloak everything in, which I've had, in proprietary or business secret. If they're really trying to protect something, then I think that should be attempted to be resolved before litigated. But it gets litigated quite a bit. I think that you also see a lot of, in addition to the confidentiality and the HIPAA issues, which quite frankly most of them should be avoided, data issues. And so we're now moving forward, and we've all served discovery on each other, and let's assume that it's the whistleblower litigating against Meredith's client. And so we have now, you know, I've given her everything I have, and typically I have less than she has because she's representing the company. So now I want things back from her. And so she's now, you know, tying me up with 1,000 metadata and search terms and things. So that goes on for a number of months. And why don't you talk a little bit about your concerns about my requests to you
Yes.
and what you do about them?
Well, here's, the issue that we have obviously on the defense side is a relator comes forward, and that's often one individual. So when we serve discovery on the relator, they may not have that many documents and there are not that many sources that they have to search. Although I will say what we've been asking for a lot, and of course we do our own due diligence and our own research, is information from their social media sites. There are some very interesting relators who post things on Facebook, who try to connect with people through LinkedIn and try to get additional people to support their case. And so we always ask for those types of social media information, because those have turned out to be gold mines for us, and there are lots of interesting things that we have found relators to be saying and then digging for information through social media sites. So that's always a source that on the defense side be sure to ask about. But from the defense perspective, and we usually are representing a corporation, the sources of data and the amount of data that could be responsive to Mark's very broad requests that come in is extraordinary. And it's extraordinary cost. It takes an extraordinary amount of time. And that's one of the issues that we always face and we often fight about. How we like to deal with it, however, is I don't want to get caught in what I call a sideshow over document production, motions to compel that involve the court, because the courts take a very dim view of having to police discovery fights between relators and defense counsel. So what I try to do is find a reasoned and measured way to come to an agreement on these are the sources or these are the custodians we're going to search. Here are search terms that we're going to do. Here are time limitations. Here are certain requests that you all have made that we are simply not going to answer, and I'm going to explain to you why. I'd rather have a back and forth discussion and try to come to some type of accommodation than get in a whole skirmish where we lose sight of the actual merits of the case, the merits of the litigation, and we get so far down in letters back and forth to each other, complaining about each other's productions, and metadata was altered and you didn't preserve these documents. That takes away from the focus on the case and getting people ready for depositions and from the important aspects of the case. And I hate to go down that road. So we try not to go down that road and try to work, and people like Mark are very reasonable to work with respect to trying to come to some type of accommodation of what is going to be the scope of discovery, and recognizing that a corporation has a tremendous amount of time and cost and effort to collect documents compared to an individual.
Yeah, no, and I think that that's good advice, and I think that people who do this every day I try to be tailored in what I'm asking for. You may disagree with it, and I think savvy defense counsel will usually say, why don't we start with this, with the understanding that if it doesn't work, and if it looks like there's cooperation, that certainly works there. I mean, we typically are making sure that you are preserving what we need, because we're always looking for spoliation, which is the best thing we could possibly do to go to a court with. And sometimes the government has to be concerned about that. There have been some cases where, in fairness, the government has many agencies, and some agency didn't get the letter. And so that's happened, and particularly if you happen to get the wrong court. But there's a whole phase in these cases, and I think these phases would lend themselves to any kind of complex litigation where data and data review, and I've seen in some places sometimes magistrates get involved, sometimes masters get involved. Frankly, I'd like to try and avoid it. I'd like to try and work it out with the parties first, so we don't get a lot of third parties involved, but that doesn't always work depending on where you are. And after all that's done, then we go to, like every piece of litigation, depositions. And I think that depending on where you are in the country, there's been a movement to try and limit the amount of discovery. I find that you can usually make motions to even the most restrictive courts to try and explain to them why they are complicated. But you have to be mindful of that from the plaintiff's point of view. If you're having trouble trying to get the kind of data you need, you then have to, I like to proceed by way of 30B6 depositions, but I think sometimes the 30B6 depositions can either be too broad or too limited, or you can engage in I've seen a lot of sideshows on the 30B6 depositions at every level. you know, who are third parties, what kind of discovery can you get from those third parties. I mean, these are things that are, I think, akin to any type of complex litigation, but because of the amount of, in a defense contracting case or a healthcare fraud case, it's often computerized data or tons of data. You might be looping the government in when you need to loop the government in, bringing in state agencies to the extent they're part of the complaint. And it's an interesting process, and if parties are attempting to work things out, which 50% of the time sometimes they are, I think you can get to where you need to be. But if they're engaging in kind of dilatory tactics at any level, then I think that that can be a problem and can then cause the courts. You have to be careful when you're going to the court, because the court's going to decide, well, who's really hiding the ball and what's going on.
That's what I was just going to jump in and say. I think that, assume for the sake of my comment that we've intervened and we're actively involved in the litigation. And the best way for a defendant to present to the court that they are the reasonable party in these circumstances, and that the government and or relator is overly burdensome in their request and is causing, you know, nightmares that should never have been visited upon this poor company. The best way for them to accomplish that is to have already worked with the government and the relator and produced, for example, the following things: organizational charts. The minute I have to subpoena or move to compel the production of an organizational chart, I know I'm winning the case. Because the first thing the judge is going to hear is, what is the defendant hiding? The other thing that the defendant should always be forthcoming and give up without any need for any kind of litigation fight or discovery fight is, what are our systems to capture the information? I'm not suggesting that the defendant walk in and immediately disclose everything that's in that system. I understand and respect the need to review it, to make sure that there isn't privileged materials that are being produced and the like. But to describe the systems in which it's retained is absolutely something that should be done right from the beginning, so that we can then together, defendant, relator, government, craft the ideas of what it is we want to get out of those systems. But the minute I feel that I need to move to compel an answer to the question of what is the system that's retaining the documents, I again think I'm going to win, because the court's going to say, what are they hiding? So I just encourage that dialogue, because at some point we're all going to be in front of the judge, and no judge, no magistrate likes to be involved in discovery fights.
Right. And the other thing is that remember, these are fraud cases. So there just aren't breach of contract cases. Well, alleged fraud cases, but that's the good point. But the discovery phase occurs after we've gotten past a motion to dismiss and struck all your defenses. So, you know, the court is saying to themselves, what are they hiding? Or, you know, why can't we get this kind of basic information? And I think that there certainly are legitimate complaints, but I think the courts, you know, don't tend to take too much time when it comes to certain kinds of things. Assuming that you get past those, there are kind of two other phases that take on a life of their own that are extremely difficult for government, I think, plaintiff and defendant, is to try and find the right kind of experts to work on these kinds of cases. And I have been doing this about as long as anybody, and I have never ceased to amaze me how bad the experts can be, because they're often completely new areas of the law for which there are really no expertise in it. And so I've seen government experts, I've seen my experts, I've seen your experts, and I all wonder how we found some of these experts. Having said that, there are some very good people that the government can sometimes get, or defense counsel can sometimes get, and plaintiff's counsel. But I'd like to hear both from the government and from defense counsel just a few moments of your thoughts on the expert phase, which I know you're always thinking about.
What's interesting about the expert phase is it really is tied to, from the government's perspective, what did we do at the point of intervention? Did we intervene as to all of the counts in the complaint, or did we surgically strike and intervene as to just some? Because one of the first things we're going to be thinking about, and frankly thinking about throughout the life of this litigation, is what's it going to look like with a jury? these are jury trials. Unless someone has waived their right to a jury. And how will we capture and tell that story to the jury? Are we going to lose the jury because we have 15 million claims that we're trying to address and purposes to show fraud? Or are we going to surgically strike and just pick the real doozies? The one where, for example, the physician wasn't there, or the one for example, the Department of Defense bought a mule when they thought they were buying a horse. I mean, are we going to pick the real screamers, as we call them? And if we are, then the expert that we choose for that purpose is going to clearly be someone also surgically selected. But the first thing we look at is, how will this play to the jury? Working our way backward from the telling of the story to the jury to getting that expert on the stand to help us tell that story. And one of the key experts that we always consider is statistical sampling experts. Dreadful as that may be from a jury appeal. Dreadful. So we're looking for someone who can explain something that would otherwise be an eyes glazed over, please deliver me from this trial kind of a moment, to someone who can really explain, here's why we do what we do, here's how I did what I did, and here's why you need to trust me. And that's expert number one, because that's the first thing we want to do, is think backward from how are we going to tell this story to the jury.
Meredith?
Experts.
You've had lots of dealings with experts, haven't
Yes, yes, lots of dealings with experts. This is because there hasn't historically been a tremendous amount of these cases that really get to the trial phase. There have been lots of experts that we have all worked with, but there haven't been many that have actually gone into the trial phase, and there haven't been many decisions with respect to experts and Daubert and theories and so forth. So it's a very untested area, sort of uncharted waters with respect to how they would actually play out in the trial setting, which is always, you know, a difficult and a challenge for us. So one of the main areas on the defense side that we obviously focus on from day one is damages. The damages aspect to these key TAM complaints is one of the worst aspects for any defendant, because you have mandatory treble damages, you have the penalties of $5,500 to $11,000 per false claim, and you can argue about what a claim is and how many claims and so forth, but damages experts are critical on the defense side, and that's who we usually bring in early on to look at the claims data and attack it from every single angle they can to get those numbers down, 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 so that we can actually even have something we can work with. And if it's a case that's going to lead, we think, towards a settlement posture, we need those damages experts, because, again, I want to attack the government and relators' theories on damages and get an expert in there to take claims off the table, left, right, and center, and find ways to attack them and get rid of them. The difficult aspect in anti-kickback cases is that a lot of the law says once, you know, there's one claim or one kickback, every single claim after is then tainted by that kickback. Then there's some cases that are good on the other side with respect to that. So damages experts are ones that we bring on from the very beginning, and they can help us posture not only for trial, but for if we know that this is going to be a settlement and we're going to have to settle this, trying to get those numbers down into a place that we can actually work in them. So experts are a challenge for sure, and I think as more of these cases go to trial, and we were 2 weeks out from a trial about a year and a half ago, and we had our experts ready to go, you know, we were curious as to how this was going to play out in front of a jury.
Yeah, and I think that Meredith raised a couple of good points. I think once you cross the Rubicon, whether you're trying the case on your own or with the government, and you've gotten past the motion and you've done the discovery, you really have to be thinking, and many people don't. I think they're always thinking that it's going to settle. I sometimes hear a lot of people talking about the juries, but they never actually met one. So, but I think when you're starting there, you have to be figuring out how every aspect of the case will be presented. And sometimes the cases, and we've had some, are so complicated, and you're involved in them, you can't, you know, you can't figure out how to present them. So that's an interesting area, whether it be experts or graphics or dynamics or summaries or extrapolations or statistical sampling. It's all, I think, a way of finding out a way to take infinity and make it into something that makes some sense. Let's assume for a moment that, and because we don't have the time today, and it really is an advocacy, although it's litigation, you've not succeeded on your summary judgment motion. So you've tried the best you can, or you've knocked out half the claim,
Okay.
but now we know it is going to trial. That typically, and defendants will spend a lot of time preparing for that, and from a litigation point of view, you want from the plaintiff side and from the government side to be always knowledgeable about the fact that good defense counsel are hoping to knock out, whatever they couldn't get out of the case at the motion to dismiss. But assuming that there's some of it still going to the jury, well, then there's really two paths it's going to go, typically, and it doesn't have to work this way, but settlement of some sort or trial. Let's spend a few moments talking about settlement, because I think it's taken on a life of its own in these cases. And I think that there were those in the government many years ago who would never think about alternative forms of mediation and ADR. And I heard some of your colleagues, but I think that tune has changed. And
Absolutely.
I think everybody thinks it's could be a good idea. People in your bar can think it's a good idea, and also. So, you're moving on a path, and maybe you have a magistrate who wants to hear it, but maybe you don't. And the case is narrowed as a result of good work by Meredith and her team of 200 who have gotten down the case to 4 or 5 claims, but she still knows that there is tremendous exposure there. And the government knows, or the Relators Council know, that they're still going to survive and get to the jury on those issues. So, someone usually raises, and it used to be that no one wanted to raise it. Now I find that there are sober discussions about mediation or ADR and how they look, and I find that to be more part of the attempt at resolution. Do you find that in
I
the government?
do, and
there has been a change, right?
I can say that we are encouraged to explore the possibilities of settlement in whatever way we can. We are encouraged to participate in, and in many instances have participated in, mediation with a caveat, and that is that we cannot agree in advance to it being binding. And therefore, if the parties are comfortable with the process of mediation, which is a significant, depending on the case, a significant process. It's a significant amount of time committed. It's a significant amount of resources committed because it's not cheap. But it is, in many instances, has been very successful, very helpful to even narrow the issue so that we know what we really need to settle, what we need to or should settle. And we have been much more willing to and much more active in participating in mediation as a result, and I think it's been successful for the government in many instances. So I would encourage it, and certainly do so in our district, if with the appropriate case and with the understanding that it can't be binding. And then the other question that comes up when you're exploring this potential settlement is the issue of the covered conduct. Because the covered conduct in a settlement it takes on a life of its own. As all of you who have been gracious in your time and listening in with us today know, a relator can file a False Claims Act case that includes as one of its counts a retaliation count under a section we all refer to them as Section H claims, because that's part of the complaint, the statute that allows a relator to plead, amongst other things, that he or she has been retaliated against for blowing the whistle as to these fraudulent allegations, or allegations of fraud. And the challenge that we sometimes are presented with is, what is the value of the settlement with respect to the covered conduct that is being released, and what is the value of the settlement with respect to the Section H claim or retaliation claim that may also be settled at the same time? Because the first thing we hear from the defendants are, we want a global resolution, we want peace in our time, we don't want to piecemeal settle this and then have to litigate that, so you have to roll in everything all at once. And another factor to consider when we're exploring these settlement postures is, are we releasing everything? Or does the relator continue to want to litigate this count and this count, the ones that we perhaps didn't intervene in, and we want to settle just these counts that we did intervene in? That's a very challenging posture. It is something that we have encountered many times, Most often, what happens is the relator agrees with the settlement and decides that they're going to allow those other counts to go away, but there is no requirement that they do so, and then, of course, there's no requirement that the defendant settle. So you have those dynamics that are pulling at you. And remember also, for those of you that are new to the False Claims Act arena, that the statute provides for attorney's fees for the relator. And so therefore, if in fact there is a settlement of the underlying False Claims Act allegations, one of the things that the defendant is going to want to know and also resolve at the same time is, what are the attorney's fees that my company is going to now have to pay for the relator's counsel, because that is a separate amount provided for in the statute for purposes of settlement.
Yeah, and those are good points, Peg. And let's talk about the settlement phase for a few more minutes, because I think it's important. And Peg touched upon some of the things that get thrown into a settlement posture. And, you know, sometimes it's a dance that the chairs keep shifting, as one defense counsel said one time to me. So it might be that the defendant and the relator and the government have decided on what they want to settle. That's great. And maybe the defendant and the government have decided on covered conduct. That's great. But then there might be ancillary state claims that have to be resolved. And they don't always resolve at the same time. Sometimes the state AGs can be more aggressive than the federal government, or they might be going after Medicaid dollars that the federal government may not be. So that typically is a dance where the AG's office might be involved with the relator and with your office. And maybe the feds would be on the side waiting for that to be resolved. Then there's the attorney's fees that have to be taken care of. Then there may be relator share issues between the relator and the government. And then there can be the not only the 3730H claim, and just for purposes of all being on the same page, that's really the private cause of action that the relator has. The first cause of action is shared with the government. So we have a derivative claim, if you will, with the government. But the 3730H claim, which from a defendant's point of view, they would like to resolve it, generally. Although there are times where maybe that's the only thing that's left, and we might decide to litigate that. So there are a whole bundle of things. And then in the settlement phase, we're going to get to the trial phase last, in corporate integrity agreements that are exclusively these two ladies that have to deal with. I'm not really generally involved, but it has, you know, a corporate integrity agreement. Why don't you spend a moment on what that can cost a company?
Well, that is a huge issue. So obviously any company that decides that we are going to enter into a settlement, we want a global resolution. We want peace on everything. We do not want another agency, you know, another authority, a regulatory authority, anybody else that's coming after us for this same course of conduct. We want one global resolution. That, I have to say, is harder and harder to achieve these days, because in addition to government agencies that we have to deal with, you have the plaintiffs' bar, class action lawsuits. Now we're seeing tons of shareholder derivative lawsuits coming forward. You have Consumer Protection Act claims coming forward. So it's becoming harder to do. But one of the aspects that I do think that the Department of Justice can exercise some control over, and frankly they've been helpful in connection with this, is with respect to settling these, OIG will come in and take a look at the conduct and determine, as part of a settlement, whether a company has to be subject to a corporate integrity agreement. These agreements have become more and more onerous on corporations. There are a tremendous amount of requirements that go into them. They are very time-consuming to ensure you're complying with them. They are very costly. They often require hiring of additional people, additional resources spent on compliance programs, and the corporate integrity agreement can sometimes blow up an entire deal that may have been reached, or it can delay a deal that's been reached 2 years ago that's still trying to work our way through figuring out what the corporate integrity agreement is going to look like. And we've had instances where I think the Department of Justice has been helpful in saying, look, we're coming to a resolution, the company is coming forward and accepting responsibility for this, let's all move forward, and maybe there are aspects of the CIA we can work with, and they can work with OIG and lean on them a little bit to help us come to resolution. There are also a number of cases where we take a very strong position on the defense side, where we are absolutely not going to enter into a corporate integrity agreement or a compliance certification agreement or anything whatsoever. These are cases where the settlement figures are in the low 15 million, 30 million, 40 million, and so forth. And we've taken a very hard line that we are absolutely not resolving the case if there is a CIA. And we go and we will make a presentation to Mary Worden, who is very fair and very reasonable, and we've just recently had success with no CIA in a settlement that we negotiated. But the aspect of exclusion powers and corporate integrity agreements can put a hinge into settlement discussions and negotiations, and can prolong them, and sometimes can really be trouble in trying to bring a resolution around.
All right.
It's interesting too, though, because I was at a plea agreement this morning in a case that was a global resolution.
But not one of Meredith's clients.
No,
Okay.
definitely not. A criminal and civil resolution, and one of the first things that was said as a term of the plea agreement was, there's no need, Your Honor, for this corporation to be put on probation. And why did the defense counsel say that to the government, to the court? He said, because they have entered into a corporate integrity agreement, and the whole purpose behind those CIAs, as we call them, is to ensure the compliance with the conduct going forward, to allow the company to avoid being debarred or being excluded, and ensure that compliance. So they are burdensome, they are very difficult in some instances to meet, but they're not without good reason.
All right, so we haven't been able to, or we have been able to resolve everything pre-trial. Let's talk for what happens that might be a little bit more unique for the trial of a modern quitom case. And there haven't been that many tried, but the ones that have been tried have been quite interesting to watch and dissect, and I think the three of us take a close look at them. And I always like to, we talked a little bit about evidence presentation, which I think is a very important area. And I think that there are a few people that maybe spend as much time as we do trying to think about those. And there's all of the usual kinds of things that one can do, but one ought to be thinking about that during the time period you have, whether it be demonstrative exhibits or summary charts under 1006 and others. But before that, I think we all engage in issue spotting, and jury consultants, and everybody around this table has spent a lot of time vetting. I used to think that they were maybe trendy or foolish. I think that they have value. I don't know whether they have, I don't know whether they're the last version on it, but I do think we all now are taking cases and taking issues, whether the government didn't used to, the government's doing that now. And I think that they're interesting because you're trying to think to yourself, as the plaintiff, whether you're going forward with the government or without the government, how do I explain this posture to a jury? And what are the kinds of things that you have to worry about, Meredith? When you're thinking about those and the jury issues, what are some of those things?
Well, there have been very few of these that have gone to trial, but we did have one that was very, very close, and there were a lot of different issues that we had to consider, and there's not a lot of precedent for how to address these. And one aspect that we've been using a lot has been to conduct mock trials, and we've been doing them now basically in almost every case, which I would say has not historically been the case, but in the last couple of years, virtually every case we are running a mock trial, at least one. Sometimes we are doing more than one mock trial, and I think that we have found them to be very helpful in helping us to focus on what are the issues that are really most important. What is going to hit home with a jury that's going to convince them that our client has done absolutely nothing wrong, and that they should be let off the hook with absolutely no penalties whatsoever. And sometimes when we get so close to a case and we are convinced that our defense is the best defense and this is the key fact that's going to win the day, and we go into a mock trial and present it, and the jurors look at us as if we're crazy, it's very helpful to have that sort of third party and that other sort of gut check of what is going to be effective, what's going to be, effective to the lay person who's listening to this, who doesn't live this case, doesn't live these types of cases day in and day out, and what's going to resonate with them. And in multi-defendant cases, of which we have a lot, we've done mock trials together with other defendants and gotten a sense of maybe this is a case in which we want to file a motion to sever. Maybe we are better off not being looped in with this other particular defendant, or sometimes when we believe their conduct is, more egregious, or they could be on the hook and we might not. I might want them in because then we look like the innocent defendant. Maybe we get off the hook. So there are different aspects of those mock trials that we have found to be incredibly helpful in helping us refine our case and getting our case ready for trial, and also playing witnesses. We play a number of the deposition clips from witnesses, and I believe there's a witness who's the best witness, who's going to be our #1 star witness, and the jurors hate that witness. And then we switch around our order and determine who else we should put in the place. So I find them very helpful, and that's something we've done as we've gotten ready for trials. And I think it's very helpful to have that jury consultant and to do that process.
Yeah.
I just wanted to jump in on one other thing, too, and it's an interesting aspect of this. Here you have, assume for the sake of our discussion that we've intervened and we're trying this case with the relator and relator's counsel. And from our perspective, we don't necessarily want to tell the story through the mouth of the relator. Meaning, no disrespect to this relator. We've accepted that person's allegations. We agree with their assessment. We've intervened in the case and we're going forward with them. But our concern is that we now have the person who might have a great deal to gain by telling the story because of the relator's share, which is the first thing Meredith's going to ask him on cross-examination. And so we need to be preparing witnesses other than the relator to support the relator's story and to tell that story in a way that is as compelling but without the additional baggage of recovery.
Right.
And that's a real challenge. And then it becomes a challenge because the relator doesn't feel that they've been given that opportunity. So many of the people that we work with as relators are people who felt they would never have come to us to begin with. They would never have gone to Mark to begin with, but for the fact that nobody listened to them from within the company. And they want to tell that story. They need to tell that story. And we want them to not tell the story. We want their story to be told by somebody else. So all of these are really challenging issues when we're getting ready for trial.
Yeah, they are good issues, and I think that I tend to err on the side, assuming you represent a relator who doesn't have too many issues that Meredith's going to exploit. I think it's better to get that all out on the open and let everybody know about it. I think juries in the United States, for a lot of reasons, are more pro-whistleblower than one would think, because I think they're sometimes seen as, a protection on government and other things. But I think that I don't think there's enough time spent on thinking about how these cases are thought about before juries. And the reason I see that is I see people scurrying around at times on the plaintiff's bar when it's finally heading there, worrying about jury charges. Well, there aren't, you don't go to a book on some of these cases. You should be thinking about the jury charge now. Voir dire of the jury. How long is it going to take? What motions? How many weeks should it be? Are you off the normal grid on that? We talked about jury consultants, but we forget that the country was built on the jury system, but sometimes it's the last place these cases will be tried, and I think they're very important. I was watching a case that Meredith had, very interestingly, because she was filing some very interesting motions in limine, which I think people forget about, are very useful, and some of them were very interesting.
You have to be creative.
No,
in
they
these
were
cases.
creative, and I would wait every time one would get filed to see how creative the next one, and I would think to myself, she's going to win this one or lose that one. But I think that's very important to constantly be getting the contours of what the case will look like. But, other what I call bread and butter issues, how long will it be? How many weeks do people have to present? Who will be in the courtroom? Who will be at the table? Who's doing the opening? Who's doing the closing? Who's doing when witnesses? I've seen it handled seamlessly with the government. And then I've seen, some turmoil at times with that. So those are interesting issues because those cases could start off, they could pick a jury, and they could settle a few days into it sometimes.
Absolutely.
They could settle at the opening. I've seen sometimes where the government has moved forward on criminal cases after they've settled the civil case, and maybe they went a little too far and they had some issues there. So there are a lot of interesting issues that if you're thinking about them all the way along, A, you're more likely to have a settlement because the side who's thinking about that is trying to find not paper witnesses for summary judgment motions, which are important, but witnesses who would survive that and would be a real obstacle to the resolution one way or the other. The court at times, I think sometimes can be fascinated by these cases because particularly if you go to a district that they don't see a lot of them, they seem to find them interesting. I think the Eastern District, for the most part, where the judges have seen them for years, are mostly interested in the cases if they think they have merit. There are some places where I think that they're either the defense counsel or the government is not used to bringing them, and maybe the courts find them to be an annoyance. But generally, I've found that if you've got past the motion and the summary judgment and you've hung in there, the judges do attempt to try and make sure all the sides are well represented. And I think that there's more, I think more of these cases are going to try one way or the other. I mean, I think that's what you and I have talked about. We have some questions that I want to get to while we have time, and I think the first one I had was for Peg, and someone asks, can a federal agency itself be a defendant in a qui tam case?
Oh, that's an excellent question.
I thought you'd like that.
No, a federal agency can't be, but having said that, we have on many occasions had federal employees or someone who is playing a critical role in the commitment of the federal funds be the defendant in the qui tam complaint or be the subject of the conduct that is alleged in the complaint. And interestingly, and I'll flip that question for those who sent it in, and thank you for doing so, we've also had some interesting discussions of whether a federal employee can be the relator. Because there was at one point there was a proposal at one point to amend the statute to make it clear that a federal employee could not be a relator. That amendment to the statute did not survive. There is no such amendment except for members of the armed services. So a federal employee could be a qui tam relator. If they are, the first thing that we do when we meet with them is to look at what their job description is and what did they do to correct this problem from within, if in fact they were supposed to be an auditor on a project or the like. And if in fact the defendant in the allegations that are brought to us includes federal employees, then that invites a very interesting investigative dilemma, because the agency that is the victim of the harm is also the agency that employs the potential initiators or co-conspirators in the harm. And so we have to be very careful when we address it that way, and we have done so.
We have about an hour's worth of questions, so I'm going to pick some, and thank you for them. They're actually all good questions. And one I'll raise, and if there's maybe divergence, do you have any advice for a relator who may have a personal cause of action against a defendant who is also the target of a qui tam investigation? Should the relator hold off on any private civil action until after the government completes its investigation? I think this goes back to the beginnings of a case, and generally when I have private causes of action and federal causes of action or state causes of action, I put them into one complaint. And I think that the case law says that the statute of limitation is told by doing that. I typically do not commence that litigation until after the government has completed its investigation, because my causes of action are going to get better if the government intervenes, in my view. But there are times where my causes of action may be separate and apart from where the government's going. Do you agree with that?
Yeah, and
strategy?
the danger that the dilemma the Relators Council has is if they choose to run with the state court claims or state causes of action in a separate proceeding, are they then running right into the potential of a public disclosure bar? Because now, unless they're an original source, they have vetted a lot of these issues in their state cause of action claim, and we've seen cases where the defendant then comes in and says, public disclosure
Right.
bar, you already litigated all of that,
Right.
it's out in the public domain, you should be dismissed as a False Claims Act relator. So those are challenges. I agree with the assessment of, if impossible to capture it all in the complaint in the False Claims Act arena, that's probably the best way to go.
Yeah, and a great example that happens every day would be a wrongful garden variety wrongful termination case or an unemployment compensation hearing where all the fraud gets thrown out.
Yep.
Meredith pays $29 to settle that, and then someone goes to a quitom lawyer, files it, and you've then argued that it's a public disclosure, and rightfully so. So I think you have to be careful and be very strategic about those and move forward. So someone asked a timeless question, Peg, which I'm going to direct to you.
Okay.
How can one determine if someone else has already brought a case against an FCA defendant to avoid preparing for a case that has already been brought?
That's an excellent question.
is.
That is one of the reasons that we encourage that pre-filing conversation. As you understand, we cannot disclose something that is under seal because that is a court order. So we can't say, oh yeah, we're already looking into all of that because we have a complaint and we have a key tam, and we can't tell you that. But we can oftentimes be able to point them to things that are public. For example, Meredith's company has gotten a subpoena from us. Meredith's company is publicly traded. Meredith's company puts things in their SEC filings like, we're working in an investigation with the government and we've gotten subpoenas. Those are ways for you to make that determination or to begin to collect the knowledge to learn whether, in fact, this is something the government is already investigating. And if it's already investigating it, then in all likelihood, there is a potential for a False Claims Act complaint to have already been filed. The other thing that we do and often do is we will ask for the court to give us permission to disclose if you do choose to go forward and file and there is one that is already in existence, so that one relator can be made aware of the second relator, because there is this first to file rule and the second relator is vulnerable to a motion.
I've seen on a handful of occasions, and I never understood why it doesn't happen more often, but defense counsel who become aware of key tam actions, who instead of waiting for 5 years, put it out in their own disclosures to knock out all other cases.
Yep.
By the time they get to settlement, the stock market and a publicly traded company has already kind of discounted it. They then resolve it for a whimper, but I don't know why people don't do it more often. I've seen a couple of very, very savvy defense counsel do it, and I called up the defense counsel and said, that's ingenious. And they never could have another case. And, and the government didn't want to take any other cases. Look, you point to it and say it's right there.
It's already there.
Yep.
But there are sometimes informal ways in which prosecutors might tell you, maybe this isn't the best case, but the formal ways are not always as quick as they'd like to be, but there's not much you can do about it.
When the first thing I say on the phone is, oh yes, I know that company well.
Yes, right. Meredith, a question comes from the state of Washington, and are all settlement agreements public, and if not, why not?
Well, I guess we've had some that do not end up being out in the public domain. Pretty much most find their way out there. You're settling with the government, you're settling with a relator, so most are certainly out there in the public. But we have had some that are, there's an awareness if someone looks at the docket that there's been a settlement, but the actual agreement is not out there.
Yeah, and there are ways that they can be done. Also, private causes of action or attorney's fees and things could be settled, and usually the government doesn't really care too much about
Right.
that.
Ours have to be public.
Yeah.
Ours are controlled in a way that, our settlement agreements are public, and the defendants and relators both understand that that is something that has to occur when we reach a resolution, but there are other claims that may be private.
We have a question from Chicago, and I'm going to give it to Meredith and to Peg Hutchinson. Can you comment on the government knowledge defense to a quitom action? How amenable is that defense to a motion to dismiss? Meredith, you want to start?
Okay. I love this defense.
I know you do.
There are a number, there's a really well-established body of case law in False Claims Act cases, and there are some that are great for the defense side and some that's great for the government and relator side. The government knowledge defense is one that we raise, I have to say, in almost every case, because I have to say in almost every case we find instances of where the government has been well aware of our client billing for this particular procedure or practice. They've been aware of it. They've done audits. They've approved claims even when this complaint has come up. They continued to pay for and approve claims going forward. So, if the government is the party in real party in interest here, and they're well aware of these claims and well aware of these practices and approving them and not doing anything about them, I think it's a very, very strong defense. Now, on a motion to dismiss, that can be difficult to get out on a motion to dismiss. Now, that is more one that we see in the summary judgment stage because there are some factual aspects to that defense. And some courts take, a more dim view, but some will take a very, very hard look at it. But it's hard on a motion to dismiss to get some of those out.
And the key with those is, what did the government know?
Yeah.
I mean, it has to be the totality of the circumstances. If the government knew and paid the claims over and over again, but didn't really know all of the facts, and if they had known all of the facts, would they still pay that claim? That's the challenge for the defendant.
We debate that all the time. We view it as, okay, if one hand knew, then everybody knew, and you knew what was going on.
But there's also a body of case law that in essence says the government is allowed to be stupid at times because
Absolutely.
it's impossible for them to be aware of
everything
that's going on. The last question, I'll give this to you, Peg, and we only have about 2 minutes, but this comes from New Jersey, and it is, what happens if a relator brings a fraud that's relatively limited but bad? Would the government be interested in that fraud, and would they investigate that fraud beyond the limited area that that relator might know about?
I actually really like that question, and I do because the problem with this statute and the way that our resolutions are announced is that the impression that we give is that we only care if it's huge dollars. And in fact, that is absolutely not the case. There is no such thing as a free fraud zone. And we take fraud allegations very seriously. We will commit the resources to investigate a fraud allegation that we deem to be to warrant our investigation. It is not about the size of the fraud, it's about the depth of the fraud. And if in fact someone comes forward, a relator comes forward, has a fraud that they're alleging with a small company or a small amount of time, but it's a deep set of allegations and facts, we're definitely going to commit the resources to looking into that and taking it going forward.
In fact, your office has been at the forefront of certain quality of care issues that didn't have large dollar amounts, but made seismic changes in the way False Claims Act as a result of some of the things you did in the early 2000s and above. So, well, thank you very much for taking the time to listen to the three of us, and we hope we were of some value.
Thank you for joining us for today's American Law Institute Continuing Legal Education webcast.